all rise.
If it would please your lordships, my name is Ashna Gunpat, and I am senior counsel for the appellant. Are your lordships familiar with the facts of the case?
I think the court would appreciate your summary of those facts. Thank you.
A police marksman suffered psychiatric injury after witnessing an unarmed 15-year-old boy being shot by his colleague during a police operation. He sued the chief constable under vicarious liability for the negligence of his colleague and the police officers stationed on the premises. At first instance, the judge held that the chief constable owed that marksman no duty of care not to cause him any psychiatric injury through shock. If my lords could open the appellant bundle of authorities, your lordships should have sight of the skeleton argument. Do my lords have sight?
Yes, I do. Thank you.
Would your lordships like an overview of the skeleton argument?
You're just going to outline to me your submissions, I assume.
Yes.
Well, please go ahead.
The senior counsel will argue in favor of the ground of appeal and submit that it was reasonably foreseeable that a bystander could suffer nervous shock when witnessing someone's death despite the lack of a close relationship with the victim. The fact that the victim was a child and that his death was the result of a deliberate act make it a more horrific sight, and suffering psychiatric injury is reasonably foreseeable. The authorities that I will be using are White and others, and Chief Constable of South Yorkshire Police and others, and Alcock and others, and Chief Constable of South Yorkshire Police. May I proceed with my submission?
Please proceed.
I oblige my lords. If my lords could turn to tab 1, your lordships should have sight of the case of Alcock and Chief Constable of South Yorkshire Police and others, which is to be found in the 4th volume of the All England Reports for 1991 at page 907. Do my lords have sight?
We have sight.
Are your lordships familiar with the facts of the case?
Do you think the facts of the case are relevant, or is it just a legal principle that you wish to outline?
The legal principles.
In that case, I think we can not listen to the facts.
I oblige my lord. If my lords could turn to sticky note A, your lordships should have sight of the highlighted text from the judgment of Lord Keith of Kinkill. Do my lords have sight?
Yes, we do.
I quote, "The case of a bystander unconnected with the victims of an accident is difficult. Psychiatric injury to him would not ordinarily, in my view, be within the range of reasonable foreseeability, but could not perhaps be entirely excluded from it if the circumstances of a catastrophe occurring very close to him were particularly horrific." If my lords could turn to sticky note B.
May I just interrupt you and ask you a question? Was this a unanimous decision in Alcock? Can you remind me?
No,
There were some dissents, were there?
excuse me?
Were there some dissenting judgments?
There was
Let me make it easier for you. Did Lord Keith dissent?
I believe so, yes.
Is it? Please proceed.
I oblige my lord. If my lords could turn to sticky note B, I will quote the highlighted text from the judgment of Lord Oliver of Aylmerton. Do my lords have sight?
Yes, we do. Is it? This one.
Cases such as Dooley and Camillard and Co. Limited, Galt and British Railways Board, and Wig and British Railways Board, where the negligent act of the defendant has put the plaintiff in the position of being, or of thinking that he's about to be or has been, the involuntary cause of another's death or injury, and the illness complained of stems from the shock to the plaintiff of the consciousness of the supposed fact. The defendant's negligent conduct has foreseeably put the plaintiff in the position of being an unwilling participant in the event. If my lords could turn to sticky note C, I will quote from the highlighted judgment.
Are all these quotes, all these dicta that you're quoting, are they all compounding with each other in order to
Yes, I will make my final.
to deliver a
suggestion.
single message?
Yes.
You mentioned tab C.
Sticky note C. I will quote from the judgment of Lord Ackner. To my lords of sight.
Yes.
I oblige, my lords. While it may be very difficult to envisage a case of a stranger suffering shock-induced psychiatric injury by the mere observation of apprehended or actual injury of a third person in circumstances that could be considered reasonably foreseeable, I see no reason in principle why he should not, if in circumstances a reasonably strong-nerved person would have been so shocked. I would then direct your lordships to sticky note D. Do my lords have sight of the highlighted text?
Yes, please.
I would not exclude the possibility of a successful claim given circumstances of such horror as would be likely to traumatize even the most phlegmatic spectator by a mere bystander. If my lords could turn to tab 2, your lordships should have sight of the case of White and others and Chief Constable of South Yorkshire Police.
The anticipation is killing me, Miss Gumpert. Are these? When are we going to have the point?
Yes, I'll after quoting from this
One more?
case. Yes.
Okay.
And others, which is to be found in the third volume of the Weekly Law Reports for 1998 at page 1509. Do my lords have sight?
The case we do, where is it that you're referring to? Is it just the Chief Constable case you're referring to, or are you referring to a specific section of the case?
I'll be quoting from the judgments.
Okay, please proceed.
Would your lordships like a brief summary of the facts of the case?
Is it the general principle again, or do you feel they're relevant, or is it simply the legal principle?
Legal principles, mostly. If your lordships could turn to sticky note E, I will quote the highlighted text from the judgment of Lord Griffiths. Sticky note E. Do my lords have sight?
Yes, please proceed.
I am obliged, my lords. The law must take us to be sufficiently robust to give help at accidents that are daily occurrence without suffering a psychiatric breakdown. But where the accident is of a particularly horrifying kind, it may be reasonably foreseeable that the rescuer will suffer psychiatric injury. If your lordships could turn to sticky note sticky note F, I will quote the highlighted text from the judgment of Lord Gough of Chively. Do my lords have sight?
Yes.
I am obliged, my lords. As the Law Commission's report on liability for psychiatric illness has put it, foreseeability of the psychiatric illness is considered ex post facto in the light of all that has happened. It is generally accepted that in considering whether psychiatric injury suffered by a plaintiff is reasonably foreseeable, it is legitimate to take into account the fact that the plaintiff is a person, such as, for example, a policeman, who may, by reason of his training and experience, be expected to have more resilience in the face of tragic events in which he is involved or which he witnesses than an ordinary member of the public possesses who does not have the same background. This is as far as it goes, and if it does not, in my opinion, affect the result in the wholly exceptional circumstances of the present case. I will then direct your lordships to sticky note G.
I can't take any more, I'm afraid.
This is.
Can I hear what your argument is, please?
My lords, I submit that it was reasonably foreseeable for the police marksman Wyatt to have suffered nervous shock from witnessing Adam getting shot. Although Wyatt was a police marksman and could be said to have a higher level of fortitude than the average man, this was a particularly horrific situation whereby he had to watch a child being killed. Killing innocent and unarmed children cannot be said to be a daily occurrence of his job. Furthermore, his colleague Europe deliberately shot this child in front of him. The consciousness of this fact may have shocked him. As a police marksman who was in the course of his employment, Wyatt could have felt that he was an involuntary participant in the act. He was present on the premises.
Can I interrupt you there?
Yes, my lord.
I've just detected some the semblance of a good argument there. Now, of all the quotes, of all the dicta that you have quoted to me, which one in particular reflects that last sentence?
Consciousness of that?
It's something to do with responsibility, I think.
It would be sticky note B.
I think it might be. It's the one referring to, yes, yes.
Cases of duly Camel.
Yes, I congratulate you. What is that principle?
That the fact that he was conscious about the fact would have caused the shock, and this thereby his illness would have stemmed from the shock. That
I think it's something to do with feeling responsible, isn't it?
He assumed responsibility by
He
being
feels.
involved. By being involved, this would be similar to the case of White, where the policeman, they had in their accounts they had recurring themes of feelings of helplessness and guilt, and
But they were unsuccessful in White, weren't they?
they were not. But
Can I just say, Ms. Gumper, you're doing a very good job, because the law is against you, isn't it? Yes. So, one, I congratulate you for discovering all of these relevant dicta, which seem to support your argument, and in that sense you've done very well. But how they fit, whether they are actually ever translated into actual concrete law, I suspect in some cases they are more musings by the judges than and therefore do not constitute ratio and actual law. But you've done extremely well to find them. Are the categories of primary and secondary victim closed in any event, or can we still play with them a little? Maybe not in the Court of Appeal.
In the case of Alcock, the House of Lords did leave open the suggestion that there might be consideration of people who are not close relatives or who do not have a close relationship of love and affection with victims, but who might, in certain circumstances, be able to recover, and they might be able to. And in White, one of the judges did mention that it might be possible to avoid the Alcock test.
Yes.
Yeah,
Yes, you may.
oblige my lord. Wyatt
I'm sorry to interrupt, but that's of course what you're trying to take advantage of here. You'd probably be better off in the Supreme Court, wouldn't you? But I see the argument.
oblige my lord. Wyatt was present on the premises and was actively involved since he had apprehended the victim's brother without using violence. Given the nature and circumstances of what had happened, it would be fair to say that Wyatt was within the range of reasonable foreseeability, despite being a mere bystander. My lords, the appellant requests for the appeal to be allowed. That completes my submissions for the appellant. May I be of any further assistance?
As far as I'm concerned, I have no more questions.
No, similarly, thank you.
I am obliged, my lord.
Thank you very much.
My lords, my name is Alexander Katznelson, and I appear as senior counsel for the respondent. May I direct your lordships to tab 1, where you will find the skeleton of the argument. My lords, I will make 3 submissions in response to the appellant in the instant case. I will begin by addressing the qualifications of foreseeability of injury and the relationship required between the claimant and the victim to determine the foreseeability of the injury. This submission concerns the application of the Alcock test, applied in White and others, and Chief Constable of South Yorkshire Police and others, decided in the House of Lords, found in the 2nd volume of the appeal cases for 1999 at page 455. I will then discuss the fortitude expected of a reasonable man when witnessing a gruesome event to which he has no proximity. It is outlined inter alia in McFarlane and EE Caledonia Limited. Decided in the Court of Appeal, found in the 2nd volume of All England Law Reports for 1994 at page 1, that it is reasonably foreseeable that mere bystanders, in the absence of a close relationship to the victim, will be of customary phlegm to withstand witnessing a gruesome event. My final submission addresses the floodgates issue that may arise in similar situations. This consideration was fundamental to establishing the control mechanisms. Defendants may be open to being liable to a wide array of claims resulting from a minor lapse of judgment. As discussed in White and others, and Chief Constable of South Yorkshire Police and others, at page 455. If it pleases your lordship, I will begin with my first submission. May I direct your lordships to tab 2, the case White and others, and Chief Constable of South Yorkshire Police and others, at page 470 and 471, paragraphs H and A. Do your lordships have sight?
Yes.
Would your lordships benefit from a brief summary of the case?
Let's hear your summary of the case.
Police officers who were either present at the Hillsborough Stadium disaster or arrived shortly thereafter witnessed the aftermath of the event. The Hillsborough Stadium disaster was where part of a stadium collapsed, injuring over 400 people and killing 95 people. The police on duty at the event were supposed to be directing the crowds, but negligently put too many people into one area. The case went before the House of Lords, who ruled that all claims should be dismissed. The claims were brought stating that the police had suffered psychiatric injury from witnessing the immediate effects or the immediate aftermath of the event. May I proceed?
And those claims were
Dismissed.
Yes.
I'm obliged. Lord Gough of Chieveley states in his speech, "The principle of foreseeability of psychiatric injury has long been held to be subject to two special qualifications. First, in assessing whether psychiatric injury is reasonably foreseeable, it is assumed that the plaintiff is a person of reasonable fortitude. Second, as a concomitant of the first, the question of foreseeability of psychiatric injury is addressed with hindsight." Lord Gough of Chieveley proceeds to state in paragraph G below, do my lords have sight?
We have sight, yes.
I'm obliged. It is right that I should conclude this section of this opinion with the observation that foreseeability of psychiatric injury, while constituting a unifying principle of this branch of the law, cannot be regarded as providing a universal touchstone of liability. Lord Gough of Chieveley then proceeds to discuss the special position of secondary victims. May I direct your lordships to page 472, paragraphs D and E.
We have sight, yes.
I'm obliged. Lord Gough of Chieveley refers to Lord Oliver of Aylmerton's opinion in Alcock and others, and Chief Constable of South Yorkshire Police, decided in the House of Lords, found in the first volume of appeal cases for 1992 at page 411. Lord Oliver of Aylmerton states, "A duty which depends not only upon the reasonable foreseeability of damage of the type which has in fact occurred to the particular plaintiff, but also upon the proximity of directness of the relationship between the plaintiff and the defendant." Lord Gough of Chieveley then states, "It has become settled that to establish the necessary proximity, a secondary victim must show a close tie of love and affection to the immediate victim."
If I may interrupt you there, Mr. Katznelson, I understand the nature of your argument, and I think that the outcome ultimately is the same. Are you suggesting, though, that the ground of appeal has been slightly poorly drafted? Because it does seem to incorporate this requirement of reasonable foreseeability.
I'm merely trying to apply the principles as stated in the case. Now,
That's exactly what you're doing.
the way the grounds of appeal have been drafted do align with the head notes of the case, but as you cannot quote from the headnotes, I'm putting together their underlying principle of reasonable foreseeability depending on the relationship
Yes.
from the claimant, from the plaintiff to the original victim.
You've understood my question perfectly. The ground of appeal seems to be suggestion, correct me if I'm wrong, that there was no reasonable foreseeability in the absence of this close
Yes.
tie. Whereas the case law seems to be suggesting that they're sort of independent. In fact, the reasonable foreseeability is almost irrelevant, and really it's simply what have become known as the Alcott control mechanisms that govern it. But I suspect ultimately that it's all embedded in some sense.
It seems to me that the Alcott control mechanisms are the underpinning principle to reasonable foreseeability as they were established in the Alcott case,
Yes.
in order to limit the claims put forward.
Yes. I wouldn't be surprised if the judges switch almost unconsciously between reasonable foreseeability, proximity. But at the end of the day, I think you're right. It boils down to the mechanisms of control. Please proceed.
Lord Gough of Chieveley then states, "It has become settled to establish the necessary proximity. A secondary victim must show a close tie of love and affection to the immediate victim. The finding I invite the court to make is that the principle, which can be interpreted from the speech of Lord Gough of Chieveley, is that in order for a secondary victim to have a successful claim, the control mechanism of close relationship of love and affection must be satisfied."
Could you remind the court what a secondary victim is, please?
A secondary victim is a victim who is not in the immediate range of danger. It is merely a bystander, someone who has witnessed the event.
A witness of the event, rather than being in any physical peril themselves.
Yes. Without the close relationship, it would not be reasonably foreseeable for a bystander of customary fortitude to suffer psychiatric damage from witnessing a gruesome event. In this case, it is evident that Wyatt has no such relationship with the victim, and as such, the law states that Wyatt has no claim. If your lordships have no further questions, I will now move to my second submission regarding the fortitude expected of mere bystanders.
Please proceed.
May I direct your lordships to tab 3, the case of McFarlane and E.E. Caledonia Limited, at page 14, paragraphs E and F. Do your lordships have sight?
Yes, we do, thank you.
Would your lordships benefit from a brief summary of the case?
I think the court might benefit from that, so please summarize.
Mr. McFarlane was a painter working on an oil rig, but he would sleep on a separate ship. The oil rig caught fire, and the ship which he would sleep on broke protocol by not evacuating all non-essential personnel, which he was one of. And they went to try and put out the fire and provide aid to the victims on the oil rig. McFarlane witnessed several explosions on the oil rig, as well as many people on fire, some of which jumping from the oil rig to their death. He suffered psychiatric injury from gruesome events that he had witnessed, and from the fear he suffered that he would be injured as well. The claim went before the Court of Appeal and was dismissed unanimously. May I proceed?
Please do so.
I'm obliged. Lord Justice Stuart Smith states in his judgment, "In my judgment, both as a matter of principle and policy, the court should not extend the duty to those who are mere bystanders or witnesses of horrific events unless there is a sufficient degree of proximity, which requires both nearness in time and place and a close relationship of love and affection between the plaintiff and the victim. Even if I am wrong in this view, I think the plaintiff faces insuperable difficulty in this case. Not only is there no finding that it was reasonably foreseeable that a man of ordinary fortitude and phlegm would be so affected by what he saw, a finding which I would certainly decline to make on the evidence, but there is the finding that the plaintiff was probably not such a person.
Sorry, Mr. Catlett, so may I ask, so why was it that in this case, the case was dismissed itself? On what grounds did they dismiss the case?
My lord, you're putting me ahead of my argument, but
Well, it's
I
always
will
good to jump around.
answer
isn't
your
it?
question.
Yeah, that's-
The reason the case was dismissed was because the McFarlane had no relationship with any of the victims of the event, and at no point was he deemed to be in the range of danger himself. So as such, he was classified as a secondary victim, and the principles of the Alcock test were applied, which he failed.
Okay.
May I proceed?
Yes, please do.
In interpreting the aforementioned principle, I request the court to find that it is expected that mere bystanders will be of ordinary fortitude and customary phlegm to withstand witnessing a gruesome event. Considering the specific facts of the case, as Wyatt is not just a bystander, but a trained police marksman, it would definitely be expected of him to have the fortitude of any reasonable person. If your lordships...
You're proceeding now to your third and final argument.
Yes.
Yes, I understand what you've done. You've spliced the argument slightly between close tie and reasonable foreseeability.
Yes.
And so what you've done is you've sort of covered all the bases, as it were. I can be forgiven the colloquialism. You are running out of time, so do you want to try and make it as swift as possible on your
Yes.
policy argument?
My lords, may I direct you back to tab 2, the case of White and others and Chief Constable of South Yorkshire Police and others, at page 494, paragraph E. Tab 2, page 494. Do my lords have sight?
Yes, please proceed.
I'm obliged. Lord Stein states in his speech, the imposition of liability for pure psychiatric harm in a wide range of situations may result in a burden of liability on defendants which may be disproportionate to tortious conduct involving perhaps momentary lapses of concentration. These risks, which Lord Stein outlined, are present in the case at hand. Policy considerations are a fundamental underpinning of the Alcock test. Furthermore, a judicial decision may cause an unjust burden on the defendant.
Could I make that decision today in any event? Considering where we are? I welcome your argument, but even if I was tempted, could I?
You are bound by the precedent established in the House of Lords.
Yes, but yeah, I take your point, but please proceed.
So it is for this reason that I submit that the court does not further the scope of liability and accept claims from mere bystanders in the absence of a close relationship of love and affection between themselves and the victim. My lord, if you allow this claim, it may send the wrong message to members of the police force and lead to several more claims of this sort in the future, causing an unjust burden on the purse of the state. My lords, it is for these reasons that I urge you to dismiss the appeal. If it pleases your lordships, and your lordships have no further questions, that concludes my submissions.
I think that's it. Thank you.
No further questions. Thank you very much.
Please proceed.
Ladies and gentlemen, the moot is now the formal mooting is now concluded. My fellow judge and I will leave the room to discuss who we're going to award the moot to and talk a little bit about the law that we will then outline to you. So when we return, we'll be able to report back to you.
Yes.
All right.